Okay, next. No signs. Okay, new business. No signs. This is. All right. Now I'll have an informal presentation discussion on the draft area need of redevelopment. An investigation for block 1002, lot 2 of block 5703, lot 11, township of Teaneck, dated April 8, 2019, for Mr. Richard Price, our planner. Mr. Price will make a presentation. I think Mr. Price will address those comments made by those who came up from the public, and I think Deputy Mayor Hill will address those comments that you were responding to. If you feel he didn't adequately respond to that, then you can cover that in your comments. There will be, immediately after his presentation, the board will have comments, and I'll open up to the public. This is an informal presentation. We're not required to open it to the public, but as I've always done since I've been chairman, even though when we've had presentations that are not required for it to be open to the public, I always have, and I will continue to do so. This board has never and will never force things or rush into things, so I'll just address that comment and we'll continue not to do so. And the fact that we're having this informal presentation is not rushing into things, but actually we're adding an extra level. We're getting a sneak peek at something earlier than its regular presentation. Normally, this would be, there's a process how this would be done, and we would actually, at the next point when this would be ready for its formal presentation with public notice and all that that's required, would be when Mr. Price would be coming. It's not at that point yet. This is a sneak peek for the board to get an earlier look at this, and for us to actually be able to give some comments to Mr. Price so that he could actually hear from us about it beforehand. So that just get a little informal overview, and Mr. Price, please go forward. And if I said anything out of line, please correct me.
No, for the record, Richard Price, I'm the township and including the board planner. So this is not a formal hearing, so I don't need to be sworn. If comments are made, that's not going to be testimony. It's not going to be part of the record on this particular matter. So that's the first thing I wanted to say. The second thing is, I just wanted to echo what Chairman Bodney indicated, is that this meeting is not necessary. It's not required by law. The board could have chosen to have our firm prepare the area need of redevelopment investigation and then put it on a formal hearing without undertaking this step. However, we thought that it would be a good idea in this particular situation to provide the copies to the board for an internal review prior to this meeting, and to also afford the members of the public an opportunity to listen to that discussion and even to comment on it this evening. So tonight is an informal meeting. The actual hearing, assuming that the board seems generally favorably disposed towards the report that we've prepared, I'm happy to take comments and feedback and make the changes before it is formally submitted for that hearing. And that hearing is scheduled, and you can put it on your calendar, for the next planning board hearing, which is May 9th. And as required by law, there will be 2 public notices. 17 days, at least 17 days ahead of the meeting and 10 days ahead of the meeting. So, and that is a formal hearing. There will be testimony. I will be sworn. I will do a presentation. And board members and members of the public will have an opportunity to comment at that particular time.
Public will have, I'm sorry to interrupt, the public will have access to the document
yes.
At some point on the website or
yes. So what we'll do is, as required by law, copies of the study. It should have on the cover. It'll have a revised date. It'll say area need of redevelopment investigation. So it will be available in Rosalind's office. And I will also work with Isa on making sure that it gets posted on the website.
Thank you.
So that will be at least 17 days ahead of that the hearing. That's required by law. But if we can do it sooner than that, we will certainly do that. So members of the public have an opportunity to look at it in detail. Okay. So let's just go back to put it in context, the process of redevelopment and what the planning board role is and what we're doing this evening. So the redevelopment process, and as was the case in this particular instance, starts with the governing body, the council, directing the planning board to undertake this investigation to determine whether the properties are what's termed areas in need of redevelopment. And the two properties that we're talking about is the two DPW properties, 1600 River Road and 1425 Teaneck Rd. Council did that at a previous meeting. You adopted a resolution authorizing and directing our firm to prepare that study, and this is the draft of that study. Now, when we go to the hearing on May the 19th, May 9th, what the planning board will be doing is they will be asked to vote whether to recommend that these properties be designated as an area in need of redevelopment. They don't vote to adopt, it's not a master plan. All they do is vote to rescission. That recommendation designate whether those properties, in fact, meet the criteria and should be designated as an area in need of redevelopment. So that's the first half of the process. The sole purpose of this process is to make that determination. There is no consideration in this process on things like, where's the DPW going to go? Is it going to stay? Is the property going to be redeveloped? What are the uses that it's going to be put to? That comes in the second part of the process, which is when the redevelopment plan is done. And the redevelopment plan, when it's done, is a document that will have a section which is very similar to a zoning ordinance, which will have, there's objectives, there's a set of uses that would be permitted, there's a set of bulk regulations, there's a set of design standards, there are requirements to make improvements in the public realm, and there are other requirements and statements that are required by law. So it will be a very comprehensive document. And obviously, at that particular situation, if the redevelopment plan is looking to do something other than a DPW, part of that discussion doesn't have to be in the redevelopment plan, but obviously questions are going to have to be answered as to where the DPW is going to go, whether it's going to stay at its current location and it's going to be moved. So, but that is not the discussion that we're having tonight. So any comments on that really, certainly you could listen to them, but it's really not part of what this process is. That will be dealt with comprehensively if and when the council designates that, and then it either can send it back to the planning board, or it can say, it can direct the redevelopment plan to be prepared by our firm, at that point. So, is there any questions about the process and what you're doing?
One question,
Yes, sure.
Mr. Chairman, if I may. So the question I have is, am I correct in saying that we should not concern ourselves with where the DPW might move to?
At this point, no.
Okay. At some point in the future, should we concern ourselves with that?
Yes, that will obviously be.
Maybe to the planning board.
Yes, and the planning board, look, the planning board is involved in the redevelopment plan itself. When the redevelopment plan is done, what typically happens is either the council will initiate the preparation of that plan, or it will delegate that to the planning board. And the way that the redevelopment plan is adopted is very similar to when the zoning ordinance is adopted. So it gets introduced, the redevelopment plan will be introduced by the council.
Back and forth.
It will be sent to this planning board, you will do a consistency review, and you will also be asked to make a recommendation or comments on the redevelopment plan, and then it will go back for a public hearing, which will be noticed, and then the governing body will vote on the redevelopment plan. So,
Mr. Bryce,
yeah.
you said earlier that we would recommend to council whether it would be an area that was for redevelopment or not for redevelopment.
Correct.
And then they would determine if it was or wasn't.
They make the final decision.
So if we tell them we think it is, they can say it's not, or vice versa.
Correct.
So they don't have to go by our
That's correct. It's very rare that that happens. I know of one, I've done about 20 of these. I know one circumstance in the borough of Dumont where the planning board said, we don't think it's an area in need of redevelopment, and the governing body said, we think it is, and a redevelopment plan was prepared. It's unusual, but that can happen.
So theoretically, we can say it's not an area of redevelopment. They decide it is.
Correct.
And then they go ahead and start the process and then send it back to us. And then we become part of a process of something that we thought wasn't. But then since they decided it was, we have to go ahead.
You will be part of the process. There are two ways to do it. Either they can directly delegate somebody like our firm to do the study, or they can say, we'll go back to the planning board, you guys prepare the redevelopment study. So in a redevelopment plan. So in either case, it has to be considered by the planning board and has to be adopted by the council.
Anybody else? No?
Okay. All right, so.
No. Mr. Rose?
Thank you.
I'm sorry.
I understand how this is intertwined with the master plan. Nevertheless, it almost seems to boil down to the fact that we're saying, this area stinks. Let's do something better with it. And this gives us the flexibility to do so.
Correct.
I know we're not entertaining anything about future use with it, so it could go nowhere at any point. But I want us to clearly understand that what we're doing now is we're commenting. We're not directing, we're not mandating, we're just commenting.
You're making a recommendation.
Recommendation, but it's similar, in a sense, either of those, it has no teeth. It's merely giving you a good opinion that we hope will be listened to.
Yeah, it's a formal requirement of the process that the planning board, in the same way that you're delegated, to do a master plan or master plan reexamination, or to consider changes to the zoning, the planning board plays an integral role, in making the determination, A, whether it should be designated, and B, on the redevelopment plan. So that your function when you, at the May 9th meeting, is to say, yes, it meets the criteria and should be designated, or no, it doesn't and it should not. Okay, all right. So I just wanted to, put that in context. So as to, and let's just talk a little bit about the report itself. So this meeting is purely an additional step, not required by law, the purpose of which really was to provide you as the planning board with a copy ahead of the actual meeting, so that if you had issues or comments about the study, rather than incorporate that into the final version that you would either recommend be designated or not designated, you'd have an opportunity this evening to get clarification or feedback, or to provide some level of criticism. That's why it was sent to you. This is obviously a public meeting, so members of the public are welcome to be here. And now that the public knows what the context is, and we're happy to share, and I brought copies with me this evening so that the members of the public can follow along. And they will be given numerous opportunities as they go through the process to be involved. So at the meeting on May 9th, there will be it will be open to the public. They can come up, they can give their opinion, they can tell the board whether or not to recommend it. They can point out, whatever they want with regard to that particular study. The hearing on the designation itself is another public meeting, so it will happen there. And then obviously, when the redevelopment plan occurs, whether there's an informal meeting or not, we haven't gotten there yet, but there will be opportunities when the council can introduce it and decide not to open it to the public, but when it comes to the planning board for that consistency review, will be open to the public. People can comment on it there, and then on the hearing on adoption, just like when you adopt a zoning ordinance, the public gets another opportunity to do it. So just want to make sure that people understand that members of the public are given 4 or 5 opportunities to have input. There is no attempt on our part, just to the contrary, to try to be as open and transparent as possible and give everybody an opportunity to read the document and have input. Okay, now to the document itself. So I think everybody, everybody is familiar with the two DPW sites. It has been the focus of studies that our firm has done, that have been considered at the council and at the planning board. I don't think it's necessary to go into any detail. We have tax maps, aerial photographs, identifying the properties. We have a series of photographs that we took during site visits to the property to illustrate the condition of the site, both the exterior and interior of the buildings on both of those properties in order to document the conditions. The real thing to, I think, for, just so that the board understands, is to focus on is the way that a property gets designated is that, as I mentioned at the prior meeting, is there are 8 criteria in the statute, the local redevelopment and housing law, and if a particular property meets just one of those criteria, that's sufficient basis to designate it as an area in need of redevelopment. And in this case, we focused on, and we found in our investigation, that there were 2 criteria that were applicable. So if you turn to page 13, where it says statute criteria for the establishment area in need of redevelopment, the 2 criteria are known as criteria A and D. That we're referencing that section of NJSA 40A:12A5, and I'll just read those into the record. The first one is, the generality of buildings are substandard, unsafe, unsanitary, dilapidated, or obsolescence, or possess any of such characteristics, or are so lacking in light, air, or space as to be conducive to unwholesome living or working conditions. And the second one is criteria D, says areas with buildings or improvements which by reason of dilapidation, obsolescence, overcrowding, faulty arrangement or design, lack of ventilation, light, and sanitary facilities, excessive land coverage, deleterious land use or obsolete layout, or any combination of these or other factors are detrimental to the safety, health, morals, or welfare of the community. And I won't go into it, but there were, we undertook an analysis based on our knowledge of this particular property. As Mr. Powers indicated, Mr. Vici indicated, our firm has been involved in looking at this particular property for a number of years, but we went back and we did another visit and we looked at conditions as they exist presently, and we've documented, and we feel that in both instances, the buildings are substandard, the buildings are unsafe, they are dilapidated, they are obsolescence. The site themselves, they're dilapidated, they have an obsolete layout. They're overcrowded. There isn't sufficient, space to do what's necessary. There is a lack of ventilation and light. There's excessive land coverage in both cases, and the functions which are being conducted on the property generally do have a deleterious impact, not only on the land itself, but on the surrounding area. So on that basis, our firm found that criteria A and criteria D are met, and that on that basis, we would say that these properties can be designated as an area of redevelopment.
Yes.
So, in regard to River Road, when you say A and D, D is because it's also dangerous for the community now to be using the areas of DPW?
It's part of it. It basically, when you look at the conditions of the property itself, that is sufficient, but it does have an impact because there are areas of the site where, for example, car washing is occurring outside, repair is occurring outside. So there's always the possibility of spills and contamination that would have an impact on environmental conditions and on neighboring land uses.
So that's why you found D also?
Yes.
Yeah.
Yes.
Mr. Chairman, if I may. So,
For the mic, please.
So, so if the buildings or the area or there's activities that are not that desirable going on, would it be fair to say, maybe I'm jumping ahead a little bit, but would it be fair to say that if those uses of those, if the use of the area as a DPW, if they were to construct a new DPW facility there?
Sir, why don't we let him finish?
Okay.
Let the questions be, if you don't understand something, you don't want clarification, otherwise let him finish the presentation.
Okay.
I'm pretty much said that. I think I can understand your question. So
now, if you
we're not,
build-
I don't think what we're saying is based on what currently exists now and how it's laid out, the buildings and how it's operated, that has a deleterious impact. We're not saying at some point in the future.
If the place
all
were
the
cleaned
buildings-
up and everything was
If-
removed,
if-
and it was cleaned up, they built a whole new
Correct.
facility where everything was
Correct.
done, and none of these things were, none of the 8 things were happening.
We're not saying that, exactly, if everything was cleaned up and you rebuilt the DPW there, it may well fit in with the land uses in the surrounding area. It's on the basis of what exists now that has that deleterious impact.
So
So we're not commenting on that specifically, but looking ahead, you know, if we went through the redevelopment process and at the end of the day, you know, Teaneck said, you know what, there's no better place to do the DPW, it's high time that we redeveloped it, and this is the location where it would be done. We'll correct all of the deficiencies, we'll do a good design, we'll stop the contamination, we'll clean up the site, we'll respect all of the environmental constraints. It's possible that it
very
could
well
fit in.
fit.
It's possible that it could fit very well. So you're not, by doing the designation, you're not precluding the Township of Teaneck from rebuilding the DPW facilities in place. And that may be one of the options in the redevelopment plan itself. I don't know, we're not there yet, but I haven't been directed to do that.
Right. Thank you.
More so there than the the Teaneck Road property.
Yeah, well, I think they're slightly different properties. What I would imagine, and you know, again, this is not really part of the discussion, but to the extent that the DPW facility at 1600 River Road was going to be rebuilt, then what I would expect is that the functions that are occurring at 1425 would move over there. There's very little reason for it to be in another place. It's kind of an accident of history. That particular property in place, it's kind of surprising that it was ever used for that purpose. That property, as you know, has already been rezoned so that a senior citizen housing.
Whatever new facility, wherever it would be built, would absorb whatever little business would be on Teaneck Road.
I would not expect that, you know, whatever happens to the DPW, I wouldn't expect the maintenance shop to stay there.
Right, I mean.
That's likely to disappear. Whether the DPW gets rebuilt at 1600 River Road or not, that's another question.
Whatever the new facility is going to be better, more efficient, and it's going to swallow up whatever was done there.
It would be consolidated. That would be the point. Yes.
Any other board members' questions? For now, any questions from the public? Mr. Powers? And Mr. Beach? Mr. Beach, why do you come first? All right, yeah,
Thank you.
I won't be long.
no problem.
James Beach again. I think this is an extraordinary presentation. Really, really an extraordinary presentation. As I understand it, you're asking to declare the DPW as an area in need of redevelopment under a part of the statutes, parts A, B, and D.
A and D.
And, oh, we're skipping D, okay. A and D. So we're saying that the buildings on River Road, the DPW, are unsafe, they're unsanitary, they're dilapidated, they're obsolescent, etc. They lack light, air, or space. They result in actually unwholesome living, that's what it says. And then indeed, it says these areas, by reason of their dilapidation, obsolescence, overcrowding, etc.
Excuse me, Mr. Beach, you have a question?
Yes, I do, I'm coming to it.
Okay.
these and other factors are detrimental to the safety, health, morals, or welfare of the community. In other words, Teaneck is saying, we allowed these buildings to fall into this condition to the point where they're dangerous to the safety, the morals, and the welfare of the community. That is some admission. You should be really proud of that. Now, I notice also that you skip over C. Now, why don't we talk about C? C talks about land owned by the municipality and the county, et cetera, et cetera, et cetera. And by virtue of its remoteness or its topography, now think about that. This is land that's practically in the river. And the last time I checked, the waters are rising around us, okay? So, by virtue of the topography or nature of the soil, this area is not likely to be developed through the instrumentality of private capital. Now, isn't it interesting that we skipped that one? Now, I'm sure there's a developer out there who's biting his tongue. Oh, he's eager to get in there and use his private capital on this area, but if we designated it under C, couldn't do that. This is a dark day, and I'm looking forward to extensive public hearings on this proposal. Thank you.
Thank you for that question. Mr. Beach?
I needed to clarify. Thank you.
No. Next time, I'm not gonna let you go up, that's what you can.
You're not going to address people at good one?
No, that's not gonna
Put
welfare.
that on the record.
No, it's not gonna welfare. Come up to ask a question and ask a question. I'm kind enough to open up to the public for questions when I'm not required to ask a question. I ask common decency. I asked you if you're asking a question.
I asked the question. Is it A, B, or D? I got an answer. Thank you.
Thank you, Mr. Beach.
First place, I appreciate, Mr. Chairman, the fact that you're going through this additional process. I think it is a useful way in which to begin to open the discussion so that at least the public has, particularly in the absence of having had this document prior to the meeting. I'm very much confused, Mr. Price, given what you have said about the fact that the future use is not actually part of this document. Why it is that you then go ahead and make the conclusion that you do on page 17, that basically says we have no business using this for the DPW facility, particularly in light of your clear recognition that it may very well be the case, or at least I'm trying to understand what you were saying is necessarily the case, that the current use would under no circumstances be proscribed. Am I right about that?
Could you repeat the question?
Okay, you basically say there's absolutely no business doing the DPW in that final paragraph. I don't know why that final paragraph is there. You get there without it. And my question is, why put that paragraph here in this document if we're not finally commenting on future use, and particularly if we're not, and you said we would not be in the future proscribing the use of this piece of property as a DPW. So
Let me just.
isn't that what you said?
Let me clarify what I said. So, when you're talking about the last piece, I'm assuming you mean the
Last paragraph before you go to that.
So-
1475.
So the first part of the third paragraph basically indicates the current situation, the current DPW, right?
Yeah.
That's, up through where it says, the site represents an industrial use with outdoor storage of vehicles and equipment in a location that is environmentally sensitive and directs traffic through a residential area. And then it also references, we're referencing what the master plan said about it, which is the master plan says that it's no longer an appropriate location given this particular context, and there may be a detriment in the future. We're not saying that this report is saying that, we're just indicating what the master plan says. So in terms of the redevelopment plan, yes, we've reached the conclusion that as it currently exists, it's not appropriate, but it's not precluding the possibility that in the future, if the facility is developed in such a manner that it deals with all of these particular issues, that it couldn't be located in the same location. Obviously, the master plan looked at the current conditions, not the future conditions where this could be addressed. So nothing in this report, I think, precludes Teaneck from considering rebuilding the DPW in a cleaner and better format in this location, provided the particular aspects that we've indicated in this report are addressed.
Given the fact that the town has known truly since 1963 and 65, with letters that you actually provided to the council in 2016, it's known that we shouldn't leave it in its current condition. Given what Mr. Beach just questioned you about, why is it that there is an advantage to moving expeditiously to address what you consider to be a wholly unacceptable condition, that one would go to naming this an area of redevelopment? And is it the case that there's only one additional advantage that the township gains by so doing, and that is its capacity, without a competitive bidding process, to convey this property to some other owner? Is there something else that's gained?
Well, I've been involved in designating areas in need of redevelopment for completely different reasons. For example, in Cranberry, we had a warehouse development where the designation was a necessary part of securing financing and loans and tax advantages from the state. So there's advantages there. There are numerous benefits of going to the redevelopment plan, even when the owner of the property is the township.
Can you name
aside from that,
Can you name them?
You avail yourself of particular funds to be able to do the under a redevelopment statute that you wouldn't otherwise be able to do.
Funds from where?
Hold on 1 second.
Sorry.
You're gonna have to let him answer.
Okay, fine.
Because the tape is gonna be wacky.
Okay.
From the Economic Development Agency, and that's in fact what we did in Cranberry. We designated as an area in need of redevelopment solely for that purpose. So that is a benefit.
But you agree that one of the main advantages for a public entity to do this.
All right, so
Okay. Am I right about that?
So let me just explain that. So if a township-owned parcel is put out for bid, typically what happens is that in most situations, the township has to accept the highest bidder. One of the things that you can do under redevelopment is that you can go through a request for proposal process where you don't necessarily have to pick the highest bidder, but you can pick on the basis of other criteria the most appropriate or the best development alternative. Now, that does not mean that you have to go through a public process. It's an RFP, it's competitive, it's evaluated. I'm doing this in Woodcliff Lake with regard to affordable housing. It's an open process. There has to be criteria that are determined. You have to come up with a redevelopment agreement. So it's not to circumvent the process of selecting a developer. It is to allow the community to take other factors other than the pure amount that the municipality is getting for the property. And that is a very appropriate mechanism because there are things about the future projects that you might want to take into consideration beyond the financing.
And when you think
The best project may not go to the highest bid.
And when you think of the value of the property, you have to consider the environmental condition of the property, whatever.
Correct.
Question on the point?
Can I finish?
Can I just ask a question at the same time?
Yeah.
Am I understanding correctly between the two of you that literally, you seem to be saying that this gives more flexibility to the township to determine the best use, and you seem to be indicating it gives more of a possibility for the township to obtain the most mayhem. It's a different perspective in terms of what the flexibility allows. I think that's...
I just don't want people to go away with the impression that Teaneck is somehow going to be doing a deal with a developer, simply because they that's the person that they want to do business with. It's a public process, and the flexibility that you have is typically when you just do a bid, you have to accept the highest bidder. In the case of where the property is being designated as an area need of redevelopment, there are other factors that can be considered before you choose that developer. But it's a public process. There are numerous steps and legal requirements that have to be followed, which make sure that the public interests are protected in that situation.
Rather than just selling it to someone.
Correct.
Just letting them do whatever they want.
Dr. Powers, can we wrap it up maybe? Can we, if
Well,
you can?
I have, there's two. First place, he actually qualified, as he should have, the fact that the township can do that. But under designated as an area of redevelopment, it need go through no public process whatsoever to transfer that property. I think we ought to keep that in mind. It can be done. It doesn't have to be done. Township probably shouldn't do it that way, but it can be done.
That's an inaccurate statement.
Well.
All right, so we'll debate this maybe
We'll
at the public hearing. Let's
I want to
debate
ask
this
one other
quick.
question. 2 years ago, you were asked by the council on the 7th of December to conduct an engineering and environmental study of this 1600 River Road property. There's only a reference in this, the fact that an LSRP is somewhere in the process. I've seen no contract come before the council that would actually constitute what I know to be the case would be necessary if you were doing a full environmental assessment of this. So I'd like to know what the status of that is. I want to point out one additional thing to this group. There is no way in which the township of Teaneck is going to avoid responsibility for the cleanup of this property by whatever jurisdiction may be done. It could possibly be under Superfund if in fact Hackensack River does become a Superfund site. It can be simply under the DEP regulations. There is no way in which this property, which the township has used, we know way back why it went there, because that was where we had the sewage treatment facility. This is a substantially contaminated property, and so therefore, any idea that the town is going to somehow get rid of that responsibility, I believe is inconsistent with everything I know about environmental law. Am I right about that?
I stand by the statement I made in 2016 that nothing has changed. Yes, we know it's environmentally contaminated, we know it has to be cleaned out, and we know ultimately, at the end of the day...
Whatever gets done there has to have a cleanup.
Exactly, and the township as the owner and the one who's contaminated the property is ultimately responsible for it, yes.
And so therefore, is it not the case that were we to take a use that was, for example, sell it for a residential use?
Through the chair.
The level of...
Okay, thank you.
The level of cleanup would have to be substantially higher.
Thank you for your
Okay,
comments,
thank you.
Dr. Powers. Anybody else in the audience wish to have any questions? Sharon's back. There's no more comments. Mr. Price, you want to wrap it up? Or?
So all I'm asking at this point is, and you don't have to take a vote on it, is there anything, whether it be a map or an aerial photograph or any paragraph or any conclusion that we reached, which you would like us to change before we forward it to you formally for considering that recommendation? You don't have to necessarily respond this evening. I'm happy if you direct your comments to Rosalind, and Rosalind can transfer them to our office. Let's say we'll do till the middle of next week, by Wednesday noon next week.
Hold on. Mr. Rose.
Thank you. How do you, I guess it's not necessarily a change, but A and D, that are of specific concern and not the others? Is that a formal statement that you make in addition to what's here?
So what our firm does is we go down the list and we say, do the criteria apply or don't they apply?
Okay.
And it was our finding that criteria A and D apply and the others don't.
Okay, and I'm wondering, because it's the same point that was made by Mr. Beach, I'm wondering why C is not there, because it seems to be, relatively speaking, a pretty apt description of the condition.
Well, in this particular situation, if you look at it, yes, certainly it's not a property that's been vacant for 10 years, we'll agree on that. It is a property that's been owned by the municipality, and in terms of its location, its remoteness, its lack of access, I don't think any of those criteria apply. Certainly, its topography has not prevented it from being used. And in terms of the nature of the soil, yes, there's contamination, but the soil itself does not make it unsuitable for the property to be developed. And as a property that's owned by the municipality, it has been used, and the question of whether it would be, I think the last sentence is not likely to be developed through the instrumentality of private capital. That's when you're talking about private land. So you're saying here's a piece of land that hasn't been used for 10 years, and unless you do the designation, nobody's going to invest in that property. That's not the case here. It's a fully utilized property. So these criteria don't apply to this property.
To continue the point just a wee bit more, I'm wondering what the last line in terms of the nature of the soil, if it's already been indicated to the best of our knowledge that there's contamination, and not quite sure exactly what the level of contamination is. Let's just say that it's very, very substantial. Would that make it, in effect, not likely to be developed?
No, because the nature of the soil is not a separate criteria. It's by virtue of all of those conditions, or including the nature of the soil, it wouldn't be developed through the instrumentality of private capital. That would only apply to the property if it were a private piece of property, not a municipal property. So that criteria applies. Let's say you have a piece of property or a building that's been sitting there for 10 years. Can't be developed, can't be occupied, why not? Well, it's one of those factors. It's remote, or that it's just not going to be. In that case, criteria C applies. That's not the case here. It is inactive. It is being used. It could continue to be used. It's really it's by virtue of the buildings and the arrangement on the site that we believe that it qualifies. So I don't see C as being applicable in this situation.
I will cross it out. Thank you.
And it's unnecessary. If we just did A, it could be. If we just did D, it could be. But quite frankly, it meets both of those criteria.
Thank you.
As long as it meets A criteria, then it's.
Only has to meet one, in this case, both of them meet two. So it more than qualifies.
All right. So any members feel that there's any need for comment or change to any of the items on there?
I'll hold it open and I'll do the final version
All right, so
in time for.
Board members, you have it to read further, and if you feel necessary, please either email myself or.
This is the same version you emailed in, right?
Yes.
All right, and we can forward it. All right, so please send it. I'd like to just instead of emailing them directly, send it here so we can follow through, so I can see the comments that I got you through to Mr. Price. So send it to me, and I'll forward it to the board.
Motion to adjourn?
Well, just a second question. For the night, for that meeting, next meeting, you're basically going to put this out to the
exactly
public
the
in a
same.
little bit more detail, perhaps, or the same
It's
detail?
exactly the same report unless you have
Thank
comments. This is the final version unless you have comments.
Gotcha.
All right, thank you very much.
All right. Now, Mr.
Motion to adjourn.
Second by Angela. Motion by Mr. Simon, second by Ms. Fulton. Any objections? Voice vote? Yes. All in favor? Yes. Meeting is adjourned.